Hey everybody, Sean with Resolve It, and today we're going to ask a question about something that's come up recently in the news with respect to the Alex Jones trial, and that is, what is noting in default, and what does it mean? What noted in default means is that you have defaulted on an amount, whether it's a liquidated amount, meaning an amount that you owe in a negotiable instrument like a loan or something like that, or it could also be unliquidated damages, that the court has noted that you owe these damages. It's pretty straightforward. How is this relevant in the Alex Jones trial? Well, you may have noticed the judge talking about liability and saying that liability in that case has already been determined by the judge. Well, it has. And what happens when you've been noted in default is a number of things. One of the consequences, biggest, most significant consequences of being noted in default is that you can't file a defense. You can't file most of your documents. So this is a very serious concern. Now, there are three ways that somebody can be noted in default. In writing, which means that you have already presented all of your written evidence to a judge, and the judge or a clerk has agreed. There's a cat behind me. That's our paralegal, Ribby. If the judge has already received all of your evidence and noted you in default, then they stamp and seal the document, and then you basically move on to the punishment phase. The judgment's been received, and the only thing to do at that point is to determine exactly how much money the person owes, and that would be done through what's called a debtor's examination, which is where you look at the assets of the person, and you try and determine if they can pay, when they can pay, and how much money they need to pay. You can be noted in default if you don't show up for a trial. That is true. That is correct. If a person shows up, one of the parties shows up for a trial that they've scheduled, and the opposing party, that is the defendant, doesn't show up, well, then they proceed, a judgment is ordered, and there might be a second hearing. I would imagine that what has happened is that Alex Jones has received these documents and he did not file a defense in the prescribed time. A lot of people are saying that he handed over documents, but one of the major documents you need to hand over is a defense. If you don't file a defense in the form that they ask you to, in the proper form that they ask you to fill it out, you could lose out on a lot of opportunities to defend yourself, to enter into a counterclaim. You can't even file motions. I mean, the only motions you can really file are motions for more time for a defense. So, let that be a lesson to you. In your case, when you have a defense to file, usually in BC, in Ontario, in many jurisdictions in Canada, you have a window of about 14 days. Depends on what court it is, what tribunal it is. There's a whole bunch of questions about that. But generally speaking, you have 14 days to respond. And that ain't much time. You got to keep that in mind. So if you receive any sort of document from a court, whether it appears to be real or not, your very first move should be to respond. So those are some of the ideas that I have about noting in default. As usual, you could like, comment, subscribe for more legal education videos. They're released every Monday at 9 o'clock a.m. on this channel. And starting in August, every Saturday, 7 o'clock Pacific time, we're going to have a legal clinic. You can show up with any questions you might have. So then you'll have somebody to speak with. So come by, ask some questions, and if you don't have time to show up to the legal clinic, ResolveItCanada at Protonmail.com. I'll answer as many questions as I can. I am a full-time professional. I don't have all day to answer your emails, but I'll answer as many as I can. And if you'd like to pay for our services, you can pay for our services too. We have several very affordable packages. The third and final way you could be held in default is in writing. So essentially, you've submitted everything to the court clerk. The court clerk hands it over to a judge. The judge looks at it. They make all of the determinations in writing based on the evidence that you submit. And this is done without notice to the defendant. The Alex Jones trial, we'll have to see what happens. You know what? I am not qualified to give an expert legal opinion about that case, But what I can tell you from what I've seen so far from the first day, there are some significant challenges on behalf of the defense, and one of them is that Alex Jones didn't file his documents on time. Most of the time, if you're in Ontario, you can do this. If you're in BC, I believe you can do this as well, is you can request a motion so that you can file some sort of defense. Now, I don't know, this obviously wasn't an option with Alex Jones. He already owes money, and now they're trying to determine exactly how much money he owes. Now, the defense has a ridiculously difficult job in the Alex Jones case. We'll have to see how that goes. So far, they're running into some pretty significant obstacles. Don't be like Alex Jones. Don't make that mistake by not filing anything at all or filing documents that are just completely irrelevant. Make sure you file the right documents at the right time, and one of the best people to guide you to do this is a lawyer or a paralegal, or even Resolve It if that's your choice. This is Sean Adams. We'll see you next time, and I believe in you. Take care.